There's a lot of debate right now and discussion about what this bill would allow and not allow. There's obviously some tension in this country between religious liberty and discrimination. This bill would protect business owners from lawsuits from people claiming discrimination if those actions were part of the business owner's religious views. So give me an example of where this might be applied. You're saying it wouldn't be applied for somebody refusing to serve a same-sex couple at a restaurant. So where would it apply?
Well, it would only apply where a person had sincerely held religious beliefs, and the burden is substantial. So, for example, if you were trying to sue or prosecute a Roman Catholic priest who wouldn't officiate a gay marriage, right, this law would protect them. If you were going after a physician who's Catholic or Orthodox Jewish physician who was against abortion, and you were suing them because they wouldn't perform an abortion, this law would in fact be a protection for that person.
Would it?
That's where it would apply.
Okay. Would it apply, for instance, if there was somebody who was religiously observant and believed homosexuality to be a sin, owned a hotel that was open to the public, and are they allowed to not let a same-sex couple get a room at that hotel?
This law would not shield that particular hotel owner or a waiter in a restaurant, because we're not talking here about substantial burdens. Let's take the case of the photographer, right? One of the reasons why this bill came to light was you had a photographer in a different state who was being sued because the photographer would not officiate or take pictures at a gay wedding. Being involved in an action, a gay marriage, that your religion says is wrong, that's a substantial burden because you're deeply involved in the ceremony. If that same gay couple came in for a passport photo, there is not a substantial burden upon your religion, and you could not use this law to do that.
But it is in the eye of the beholder, I suppose, where that substantial burden is. If a physician, for example, disapproved of homosexuality because of his deeply held religious beliefs, he could refuse to treat a sexually transmitted disease of a gay man? Would that be a part of the significant burden?
No, not under this law, because treating a sexual disease with anybody is not a burden on one's religion. I think what you have to understand is that these laws, this protection, they came about by the federal government in the 1990s. Arizona passed a particular law. And what the federal and the state law says is the government can't substantially burden a person's free exercise of religion unless there's a compelling reason, and even then, only in the least restrictive manner. All we did the other day was put two changes to that law. The first change was we clarified that the definition of a person, the ones protected by this law, are not just individuals, but also corporations and associations. And the Hobby Lobby case was the reason for that. The second thing we did was we expanded what it protects against. The original federal and state law says it only protects you against a government action. We said, hey, this should also cover a private person using a government law or the government courts.
But Representative,
and as a concession.
Representative
Yes.
Kavanaugh, to a lot of gay and lesbian couples and to people who believe there shouldn't be discrimination against them, it sounds as though you're saying businesses now, if somebody has a religious objection to what they do, it sounds as though you're saying they now have an ability to discriminate. I don't yet understand exactly where this burden is. Examples I give you say they don't meet the burden. Where is the line?
They're incorrect. Look, the law about the substantial burden, that's been in effect federally and at the state level since the 1990s. We simply changed who it protects and included associations, and we said it also covers somebody when they're being sued based on a law. In addition, we increased the protection against discrimination. We said that the religious belief can't be any religious belief. It has to be a sincerely held belief. And then we said the burden can't be any burden on religion. It has to be a substantial one. We made it harder for somebody to hide behind this law. So I don't understand why now, since the 1990s, there's been no concern or no demonstrations about this. We pass a law that does minor clarifications and makes it harder to discriminate, and they're taking advantage of it to get publicity.
Obviously, your opponents disagree with your assessment.